First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and ye shall be heard. May God save these United States, great state of Florida, and this honorable court.
Thank you. We are here today for one case, Sawgrass Mutual Insurance Company versus State of Florida. Is the appellant ready to proceed?
We are, Your Honor.
You may.
May it please the court, David Healy for the appellants. I would like to reserve 5 minutes of my time for rebuttal. Your Honors, we're here today seeking reversal of orders of the trial court appointed the Department of Financial Services as the liquidating receiver of Sawgrass Mutual Insurance Company, as well as related orders denying the company's motions to dismiss and for rehearing. For the reasons we're prepared to show, we contend reversal is required for any number of reasons. First, and most primarily, in what we would characterize as an unfortunate rush to judgment, the trial court found, in the face of completely conflicting affidavit testimony, that Sawgrass was statutorily insolvent. The trial court did so at a mere show cause hearing required by section 631.021 subdivision 3.
Counsel, with respect to that show cause hearing, isn't the sole issue before the court insolvency? And I guess if that's the sole issue, you essentially raised almost a due process argument that you didn't have adequate time to address the issue. What would you have put on? How were you inhibited by the length of the hearing?
We were, if the court reviews the transcript, the hearing was originally set for a mere 1 hour, was extended to an hour and a half. And then the trial judge did give us 3 hours before the lunch hour intervened. Most of that time was consumed dealing with preliminary motions to dismiss, motions to intervene, potential settlement, such that the show cause portion of the hearing on the clock was effectively less than 30 minutes. In doing so, we started by offering and proffering the affidavit testimony of Mr. Marvin to show point by point that in rebuttal to the department's own affidavit testimony, that Sawgrass was not insolvent. We also requested both in pre-hearing motions and at the hearing that we be allowed to put on evidentiary testimony to bolster that affidavit testimony, which we contend was sufficient in and of itself to show good cause and require further hearings, which we were not allowed to do. And so our main argument is, first of all, that by our responses and affidavit testimony, we showed without more that there was good cause for the trial court not to appoint a liquidating receiver, at least at that juncture in the case. And very similar.
I guess my question if you could address my question, is more to what more did you want to do? I know that you proffered the agreement and you had at least one, if not more, witnesses available, but then did not call those. And I don't see in the record that the court said, you're not calling them, I'm not going to let you call them. So what more would you have wanted to do? What were you restricted? What was restricted?
If we had been allowed to put on testimony, it would have obviously been consistent with the proffer, the agreement that we offered, and Mr. Marvin would have been prepared to testify at even greater length to what processes and arrangements that the company had put in place and intended to put in place to address any bona fide creditor claims. And we were denied the opportunity to do that. Moreover, in addressing the due process argument, we had also requested time to do even minimal discovery of the department's affidavits, which was the sole basis that the trial court actually relied upon. And we had been given an opportunity to conduct discovery. We're convinced that we would have shown flaws even more than we demonstrated at the hearing to the department's case in chief.
May I ask you, the critical facts or supposed facts are not really in dispute, I don't think, are they? I mean, you have the debt due to the catastrophic fund, some other, I guess, somewhat disputed debts. your argument is a $500,000 escrow account check should have been considered as a resource. And then there's the $300,000, the deposit, as I recall. And so if you add up every asset that you continue to have, and that you think the trial court erred in not considering, especially the $500,000 account, which I mean, deposit, which I believe is in your trust account, and or was. So are you in the black at that point?
That's correct, Judge. We felt very strongly, and that taking into account all of those assets, which should have been considered, that we were in the black from a statutory accounting basis.
Can you give us just a quick rundown of that mathematical equation? I just so I think it can crystallize the issue here. You've got the 500,000, the 300,000. I think you had 167,000 in the bank.
That's correct.
And to kind of use a reverse dynamite charge that they use in the trial courts, what's the worst case scenario from your perspective as to your debts?
On the record before us, using those funds to address and pay the CAT fund claim, we would have been several $100,000 in the black on a balance sheet basis. And
what about the debt that the department argues that you owe to the other creditor, the trust, I believe?
Yes, Your Honor. Those were completely disputed debts. And for the reasons set forth in our brief, and as shown by the application of statutory accounting principles, those would not be recognized liabilities of Sawgrass, at least until they had been adjudicated and liquidated to judgment.
Because your argument was that one debt was a walkaway settlement agreement?
You're referring, Your Honor, to the Holborn Corporation debt. Yes. There was litigation and there was a settlement for a walkaway that would have been implemented, but for the department's intervention. And the remaining claims for JLT Ray and certainly the Heritage Insurance Company claim were very much disputed. And as the record reflects below, particularly the JLT Ray claim, we didn't even know of that claim until the department, with OIR's assistance, showed up with an affidavit claiming that was owed.
And how much was that reinsurance claim again?
It was, I don't have the number in front of me, but it was, I believe, in the $300,000 range. It was a substantial claim, but it was disputed, and with good basis to dispute it.
So your argument is the trial court was required to have essentially an evidentiary hearing or a mini trial to follow up on the show cause hearing?
Precisely. In other words, that we contend the trial court should have followed the precedent set forth in the Cypress insurance case.
And all these creditors claiming monies owed would be subject to cross-examination under oath?
That's correct, Your Honor. We would not have had a liquidating insurer appointed on completely conflicting affidavit testimony. Yes, we wanted the opportunity to test those claims.
Well, I think the critical to me alleged assets, the 500,000 in the agreement, and the trial court found that that was not an asset, that it wasn't freely accessible by the company. Could you address that?
Yes, Your Honor. This deals with arguably somewhat arcane principles set forth in Chapter 631 and Chapter 625. The issue is whether the $500,000, as evidenced by the escrow agreement, is an admitted asset that could be counted towards an insolvency calculation. We cite the court to the provisions of Section 625.012 that, among other things, say that an admissible asset will include cash or cash equivalents in a bank account, which this was, and also at subdivision 17, other assets not inconsistent with the provisions of this section deemed by OIR to be available for payment of claims or losses. And we contended that, in looking again to the Cypress insurance case for inspiration, that should have been counted as an admitted asset. We concede that OIR had not approved of it because there was no time to do that. But there's no reason to suspect they would not have approved $500,000 sitting in a law firm's trust account as being available to pay, if needed, creditor claims. So yes, we felt very strongly that the trial court erred in not considering that. And with due respect to the trial court, there was a principle of accounting, namely the statute I just cited to you, that would provide the basis for the court to count that asset. Again, as had been done similarly in the Cypress insurance case.
And do I understand I'm sorry, Judge Osterhouse?
Oh, I was just going to ask, do we run up against the statute provides a process here in order to show cause to go out, and then what it calls a show cause hearing, a full show cause hearing. And do we run up against a limitation in the statutory process that's here if we extend this process out and attach a trial, join a trial onto the end, a discovery period and whatnot? It seems like this is it has to commence within 60 days, that this is intended to bring some expeditious resolution and not an extended process.
We fully agree, Judge. This is meant to be an expedited process, but consistent, as your colleague pointed out, with the requirements of due process and other provisions of Florida law. As we cite and state in our brief, a show cause hearing is typically meant to be just a preliminary basis to determine whether further proceedings are required. We show that in this case.
But is that true with this statute, where it seems to contemplate the court shall either deny or grant an application after the show cause hearing?
That just commences within 60 days, as the court points out. It doesn't require it to be completed within a certain amount of time. And I would note in this particular case, the record below was clear. There were no policyholders at risk. This company did not pose a systemic risk to the Florida insurance market. And therefore, we would contend there was no need to go ahead precipitously and appoint a receiver. Instead, the court should have bounded over for expedited further proceedings. We're not talking about a trial in a year. And I would note that the same jurisdictional statutes at play here gave the trial court necessary and proper authority to do any other orders that it needed to interim during the litigation, if that was required. We were already not prohibited from writing insurance. We weren't doing any business. The order to show cause already prohibited us from wasting assets, required to turn over all the books and records to the department. So there were robust procedures already in place or available to the trial court to protect all the interests, if needed be, while the proceeding went forward. And that's all we were asking for. And we were denied, unfortunately, the full hearing, quote unquote, that the legislature said we were to get. I'll reserve the balance of my time unless there are further questions.
Thank you. I'll allow you an additional minute. We'll give the applicant an additional minute just to kind of round out the time, since we asked quite a few questions. The applicant may proceed.
May it please the court. My name is Gigi Rollini with the Stearns Weaver Law Firm. I represent the Appalachia Department of Financial Services, Division of Rehab and Liquidation. I want to start with the issue regarding whether or not some other process was due below. The fact that a litigant shows up to a duly noticed evidentiary hearing but does not have evidence to put on at that hearing does not make it a summary process and does not make that process somehow deficient under the statute. Upon the receipt of the department's petition, the court properly reviewed the evidence at a noticed evidentiary hearing to determine the sole question that was before the court, which was whether or not Sawgrass was insolvent, weighed it and granted the petition exactly how the statute indicated was required. Section 631.031 subsection 2 requires, on the return of such order to show cause and after a full hearing, the court shall either deny or grant the petition. Nothing cited in the briefs requires a two-step process, and there is no default order to show cause system that's applicable here. The statutes that appellant is citing in the briefs are other statutory order to show cause proceedings that specifically instruct that two-step process is supposed to happen in those types of proceedings, including in residential foreclosures. The statute at 702.10 actually reflects that two-part process is supposed to occur. And the Raplevin statute does the same. While it's not cited in appellant's brief, 78.061 Florida statutes does cite to another statute, 78.067, and that two-step process is actually defined in statute. What this tells us is that the legislature knows how to make a two-step order to show cause process if it wants to employ that.
Counsel, may I ask if the trial court erred in determining the $500,000 trust account was not an asset, does that require reversal?
No, it does not, for a couple of different reasons. First, while there was an assertion that there was $500,000 in cash offered, there was no evidence in the record that it was actually accepted. We wound up getting an agreement that was put in after the trial court ruled merely as a proffer, that if you actually look at the terms of the agreement, even had that evidence been considered by the trial court, it made very clear that all of the legal and equitable title in that $500,000 cash offering was still belonging to Mr. O'Neill, and it could only be made available if the board chose to accept it and if a number of contingencies actually occurred. Insolvency under Chapter 631 means that all the assets of the insurer, if immediately available, are still not sufficient to discharge all liabilities, or that in the ordinary course of business as debts become due, the company cannot pay them. What we had here was far more than $500,000 in unpaid debts that were either due or coming due. And the $500,000 cash wasn't an allowed asset for a very important reason. Under the statute, it has to actually be owned by Sawgrass to be able to count. It has to be, and if you look at the statute definition of cash or cash equivalents under the statute regarding allowed assets, it has to be in the possession of the insurer or in transit under its control for it to actually be counted as an allowed asset. None of that had occurred at the time of the hearing. And Sawgrass's agreement, to the extent it really could be called Sawgrass's agreement, this cash offer agreement that Mr. O'Neill put forward, doesn't indicate that any of it was in the control of Sawgrass or owned in order to be counted as an actual Sawgrass asset. On top of that, not only was there a $500,000 unpaid premium,
Counsel,
but
if I could interrupt you quickly, I'm sorry, if I could interrupt you quickly on that point. If I understand the chronology correctly, when the receivership application was put in, there was no agreement. This agreement came about after the application for receivership, but before the show cause hearing. Could you address, under the statute, is a party or insurer able to cure an insolvency situation between the application and the show cause? And in looking at the verb tense of the statute, it wasn't clear to me whether a company can cure, or if the key point is at the time of application.
It's a great question. And this is a question that came up in the Cypress case that this court previously addressed. And in that particular case, which was from a while back, the Department of Insurance was actually the party in that case, and their position was that the statute doesn't allow for a cure to occur. And part of that's because while the company is actually under administrative supervision, everything that's part of a plan to pay any kind of debts in order to try to avoid insolvency is a plan that has to be approved by the state of Florida Office of Insurance Regulation. And there was no dispute below that Sawgrass was under administrative supervision and under a consent order at the time. The Cypress case was a little bit different because you had multiple states that had regulators that were addressing a company that was potentially insolvent in a number of different states. And Cypress was able to negotiate and get approval from regulators in another state to be able to resolve certain debts that then impacted Florida. The Department of Insurance still wanted to say that they had to have approval for that as well. And this court disagreed because it was in fact approved by the regulators in another state and was completely done and effectuated by the time of the hearing. Then at that point, the trial court couldn't find that Cypress was insolvent, and ultimately determined that the company was solvent at the time of the hearing and therefore did not appoint the receiver. This case is different because we don't have any other states in place. There are no other regulators. And if you look at the terms of the consent order that's in the record, it does indicate that the Office of Insurance Regulation was required to approve the plan for the payment of anything that was going to occur during administrative supervision, not just since the department filed the petition, but actually all the way back to the entry of the consent order. So there is some question about whether Sawgrass here had any ability to go out and negotiate away its debts. And in fact, the statute contemplates that kind of serial negotiating down of debts is one of the things that allows the trial court to find that company's insolvent. So here again, this doesn't necessarily mean the fact that we have this expedited proceeding and we have the 60 days in which the case has to go to hearing on the order to show cause. And even though we have an evidentiary hearing that's set by that order to show cause, and even though Sawgrass is told in that order to show cause that it needs to produce a list of witnesses and documentation that's going to be presented at the hearing, we have a circumstance where Sawgrass shows up to the hearing and admits that it is not prepared to put on evidence. However, while Sawgrass complained that it didn't have enough time, there also wasn't an explanation why the almost 60 days that had run between the order to show cause and the hearing wasn't sufficient in order to engage in whatever Sawgrass saw fit to engage in, including potentially discovery. While there was that claim to need more time, there was no real explanation of why more time was needed or any actual motion for a continuance on which a ruling was ever secured. So the department never took the position that you can't continue the evidentiary hearing. But what we have here is that Sawgrass never secured a ruling on any kind of continuance in order to enable it to come back and have another hearing. Additionally, this hearing was originally set for October 9th, and the record shows that it was moved up to October 1st at the convenience and the request of Sawgrass to accommodate Sawgrass's counsel. So the claims at that hearing that more time were needed really they're belied by the record that more time was really needed, and there was no ruling on any kind of continuance that would allow Sawgrass to come back and have an additional opportunity to put on evidence. It's also important to look at really what these debts were that the Office of Insurance Regulation was concerned were coming due. We have this $500,000 cash offering that was never approved by the Office of Insurance Regulation. It's pure speculation that the office would have ever approved a cash offer that was sitting in an attorney's trust account, wasn't owned by Sawgrass, and had all these contingencies put on it by a former CEO within that agreement. It's complete speculation. And the cash offering wasn't even made until a very short period of time before this hearing. And it's not clear that it wasn't offered in part to try to delay the hearing. Under those circumstances, it's complete speculation that the office would have ever approved that cash approval. And it certainly hadn't been approved at the time of the show cause hearing, which under the Cypress case is the governing timing that counts. When you couple that with the fact that you had unpaid contractual commissions for reinsurer JLT that were earned but not paid prior to the insolvency hearing. That figure was around $565,000. There also was a CAT fund total premium of $2.2 million still owed for the period of June 1st, 2017 through May 31st, 2018 that came due prior to the insolvency hearing. In addition to these things that Sawgrass claimed were contingent liabilities that it was willing to litigate, that it intended to litigate. But again, none of that had occurred at the time of the insolvency hearing. Under Chapter 631, it's mandatory that if the Office of Insurance Regulation finds a company to be insolvent, it shall send that case to the department, and the department shall file a delinquency petition. Upon receiving that, the court properly reviews the evidence that comes in, holds a show cause hearing within 60 days, and then shall deny or grant the petition. It's a very perfunctory process that's set forth in statute. Again, the legislature knows how to make a more elaborate one if it chooses to, and it hasn't here because the purposes of Chapter 631 are not to protect the insurance company. They're to protect both creditors and policyholders. It's to ensure that the assets of the estate of the insolvent insurer are protected. So protracted litigation would do the opposite. It would drain the assets of the estate. For the same reason, the department is extremely concerned at the appeal that's been taken here. There's no record evidence that this is an authorized appeal by a board of directors of an insolvent insurer taking an appeal and in the actual shoes of that insurance company. What we have here is a single former director and a single former officer concerned about their reputations taking an appeal. And that's the type of thing that could happen from any ex-employee that claims to have an interest in a company being declared insolvent and going into receivership. The trial court expressed those concerns about the possibility of the floodgates if anybody who was an employee could claim an interest, and also expressed the fact that the legislature has determined there are certain fallouts that happen that are mandated by statute in the event that a receiver is appointed. And that includes that the former officers and directors are discharged and they no longer speak for the company. Again, this is to protect the assets of the company.
I guess on that issue, and that was one of my concerns, was that, you know, there has to be an available appellate avenue. So who would be the proper party according to the department?
So there are a host of ways in typical receivership cases, whether they're in state or federal court. This is an extremely common issue that can come up regarding how do you take that appeal. And there are a number of cases that we've cited, albeit federal cases, that can be instructive on what those paths are. First of all, I don't want anybody to be concerned that this was, you know, some sort of surprise. It's all over the record that everybody knew, and that Sawgrass was acknowledging that if a receiver was appointed, then the directors and officers and management would be discharged and would not be able to seek appeal through their own persons. However, there are many things that can be done, including you can request a stay and have an evidentiary hearing on the stay factors and whether a stay is appropriate. You can seek a stay for the limited purpose of appeal and get that permission from the trial court. In the event that the trial court determines that it's not going to drain the assets, it's not going to be against the public interest in order to permit that to occur. And at the same time, they can also get permission ahead of time before the receivership is actually instituted from the department to be able to take a limited appeal. Again, the department's not there to, you know, harm a company. They're not trying to shut businesses down, but they are trying to protect the assets to make sure that the claims can get paid out of whatever minimal assets there are. And here in this appeal, where we've been pending for almost 2 years, it triggers all kinds of other statutory things, including, for instance, if the Florida Insurance Guarantee Association needs to step in and pay claims, they can't until any appeal of a liquidation order is completely final. So if any employee can take an appeal like has been done here, then it can actually prevent policyholders from getting their claims paid for a year or 2 years until that liquidation order is final. And so who can appeal, and making sure that that's being done in the proper way is incredibly important. And it's also important to ensure that there's oversight so that the company's not just paying for litigation and draining all the assets so that none of the outstanding claims can actually be paid. So here, I mean, it's not entirely clear who's paying for any of the litigation, because there was never a hearing below where a stay was properly requested and that
Counsel,
evidence would be explored.
Counsel, your time's expired. I'll allow you to briefly conclude.
Thank you so much. There's ample record evidence and the statute supports affirming on the merits. However, because of the concerns about the delay and the other statutory triggers that occur regarding an appeal, we hope that your honors will consider dismissing the appeal out of fear that precedent might be created that would allow any ex-employee to try to stand in the shoes of the company and appeal in the future. Thank you so much for your time and consideration.
Thank you. I'd ask the clerk to add another minute to the appellant's time, which should give him 4 minutes. Thank you.
Excuse me, addressing several of my colleagues' points. First of all, I agree and stand corrected that the JLT Ray claim was $566,000, Judge Thomas, in answer to your question. But looking to the actual merits, let me first turn back to the $500,000 escrow agreement. Again, we stated that, that should have been counted as an asset. The issue about securing OIR approval, there just wasn't sufficient time to do that under the expedited process we were doing. And again, citing to Cypress Insurance, there's no reason on this record to believe that OIR would not have approved that as an admitted asset.
Now you dispute the reinsurance claim, correct?
Correct, as well as the.
What about the $2.2 million catastrophic fund premium that the opposing counsel mentioned?
I believe she was referring to Heritage Insurance's claim, which was in that range, which was completely disputed.
I thought she said the catastrophic fund was due $2.2 million. Is that not correct?
I don't recall that. The CAT fund claim, I believe, was in the $566,000 range or thereabouts. It wasn't 2.2 million, or at least that's not my recollection of the record.
And what's your position regarding the reinsurance claim? Is it your argument? Would it be your argument at a future hearing that it's zero?
The argument would be that claim under the contract was owed not by Sawgrass, but by the reinsurance company itself. JLT Ray was the broker. And as is typical, the insurance reinsurer pays that claim. The JLT Ray contract said Sawgrass paid it in only one instance if Sawgrass had discharged the broker during the term, which we had not, which was.
One concern that arises from this argument is what's going to happen if we rule against you to the $500,000 in your trust fund? Are the appellants going to say, well, you've liquidated us, you refuse to recognize a $500,000 asset that we had argued was applicable, therefore we're going to take it back? Is that possible?
Very possible, Your Honor. In fact, it's already happened. As soon as I got back from the October 2018 hearing, and in my notice of filing, the proffer of the agreement, I noted that my firm had received a demand for the return of the funds because one of the contingencies had been triggered, namely the appointment of a receiver for the return of the funds. So we're not holding those funds and haven't since October of 2018, as was aware to all the parties. Addressing other points, I would note and commend Judge Thomas, the Cypress Insurance case, again, in response to your questions about whether an insurer can cure any alleged insolvency between the time of the petition and the time of the hearing, and specifically notes 2 and 3 in that opinion, where the department itself in that case conceded that
Well, I
such-
think you can. I mean, I think that's the whole point of the process. And it's an expedited process. If you can cure it before the show cause hearing, then obviously that should be considered, I would think, without
that was, we read
making
it.
a, without announcing a ruling, or, I mean, that seems like a logical argument to me. But
Very briefly, the nature of the hearing, I would note for the record that the Arterbarn affidavit that the department relied on extensively was filed a mere 5 days before the actual hearing. So this notion that we had adequate time to get ready to rebut the department's case, I think is belied by the record and how they proceeded.
well, I have to ask you to briefly conclude.
Your Honors, this was an unfortunate rush to judgment where the state, on a completely disputed record, injected itself without necessity. There were no policyholders, there were no overarching concerns into the private affairs of a company by taking it over summarily, ousting its management, banning them in the process from any position in the Florida insurance industry as a consequence. When Sawgrass was not insolvent on the record and was prepared, if it given an opportunity,
All right.
to demonstrate. So we
Thank
ask
you.
for reversal and a remand.
Thank you both for your excellent arguments. The court is in recess.